Okay. Uh, Soha and Kiran,
Yes, sir.
can we start our program?
Yes, sir. Sure.
Okay, okay, great,
Am
great,
I,
everyone.
am I audible, sir?
Yes, yes, you are audible.
Okay, sir. Good morning, everyone. I, Sohasha, would like to welcome you all on behalf of Rare Shikshan Sanstha, Ismail Sabmulla Law College, Satara, in association with IMLCA Career Katta under JMFC lecture series on silent features of Constitution of India. Today's lecture will be given by Honorable Dr. H.D. Kulkarni, sir. Now, I would like to request Kiran Shinde to welcome and introduce our guest. Over to you, Kiran.
Thank you, Soha. Good morning, one and all. I am Kiran Sanjay Shinde, student of NLC 4, Ismail Saib Mullah Law College, Satara. On behalf of Ismail Saib Mullah Law College, Satara, I welcome you all for today's lecture on the topic Salient Features of the Constitution of India. It is a great pleasure to welcome our guest of honor, Honorable Dr. Harish Chandra Gopal Kulkarni, sir. On behalf of everyone present here, let me extend a welcome to you, sir. Honorable Dr. H.G. Kulkarni, sir, pursued BA in English from Yashwantrao Chavan Maharashtra Open University, BA MS from Pune University, LLB from Shivaji University, where he stood first in university, LLM from Pune University, where he stood second in university, NET and SET in law, and PhD in law from Shivaji University. Sir has teaching experience of over 29 years now. Sir has been lecturer in law for 13 years at Ismail Saib Mullah Law College, Satara, contributory lecturer for 10 years in Department of Law, Shivaji University for LLM. Sir has been principal for 10 years in DGB Dayanand College, Solapur, and also principal in Sinhagad Law College, Pune for 5 years. Sir also provides research guidance to students. He is a recognized guide for PhD in Shivaji University, Solapur University, and Dr. Babasaheb Ambedkar Marathwada University, Aurangabad. 3 of his students were awarded PhD degree in Solapur University. One PhD student was awarded PhD degree in Shivaji University, and one PhD student was awarded PhD degree in Dr. Babasaheb Ambedkar Marathwada University. Also, 4 PhD students are currently registered with Sir and conducting research under his guidance, out of which one student has submitted her thesis for evaluation to university. Sir has been at the position of Dean in Faculty of Law and Chairman at Board of Studies in Solapur University, and in Shivaji University, Dean in Faculty of Law, Chairman at Board of Studies in Law, Member of Management Council, and also Member of Senate. Sir has participated in about 40 conferences, seminars, and workshops as resource person. To cite few colleges and departments of law are Pune University and Shivaji University, ILS Law College, Symbiosis Law College Pune, NS Soti Law College Sangli, Shahaji Law College Kolhapur, MP Law College Aurangabad, BV Bellad Law College Belgaum, and many more. Sir has been resource person to state level conferences held at Aurangabad, Solapur, Chandrapur, Amravati, and in many colleges in Pune University. Also, he has been resource person for 1 week faculty development program, workshop on anti-ragging law, workshop for principals and directors, national seminar on rule of law and frontiers of judicial activism, state level seminars on appointments commission, issues and perspectives, and seminar on topic Dr. B.R. Ambedkar and Constitution of India, organized by Babasaheb Ambedkar Research and Training Institute. He has delivered about 26 guest lectures in various law colleges and departments, and elsewhere on various occasions and various legal and social topics. Satara Akashvani has broadcasted his talk on 3 legal topics. His various articles are published both online and offline as well in various reports, journals, Indian Bar Review, and Environmental Studies. Few are Right to Health under Constitution of India, Erratic Dimensions of Law, Legalizing Euthanasia, Medical Profession and Law, Implementing the Constitutional Mandate of Legal Aid, Modes of Execution of Death Sentence, Past, Present and Future, Rule of Law and Independence of Judiciary. 2 of his online published articles are Tips of Studying Techniques and Thesis Writing in Legal Research. About 12 more articles are published in Law Z, Legal News and Views, Souvenir of Maharashtra Federation of Principals, Association of Non-Government Colleges, Souvenir of Medico Legal Association, Bhavan's Journal, Law Journal, various periodicals, and newspaper. We are very fortunate to have you today as our guest lecturer, sir. I am sure your achievement have indeed inspired all of us, and we all are eager to learn more from you, sir. I once again thank you, sir, for being here today, and it's over to you, Soha.
Welcome, sir, on behalf of Ismail Sir Mullah Law College.
Thank you.
We thank you very much for sparing your time for this particular lecture. I must say she has given your introduction, but the thing which I would like to share with all is Dr. H.G. Kulkarni is student of this college, has been teacher of this college, principal of this college, and dean of Shivaji University, Kolhapur. I know that he is a strict disciplinarian, he is a very good administrator, and the elite personality with great legal acumen. I'm sure all students today, all lawyers who are aspiring to be to clear the JMFC, all of us will benefit by his informative lecture. Thank you, sir, for joining. Welcome.
Thank you, ma'am. Now I would like to request Honorable Dr. H.G. Kulkarni, sir, to guide us on today's topic, that is salient features of Constitution of India. Over to you, sir.
Hello.
Hello.
Yes, sir. You are audible. Yes, sir.
Okay.
Okay.
Today I am going to discuss with you salient features of the Constitution of India, which also mean a philosophy underlying the Constitution of India. After all, what is a constitution? Constitution is anatomy and physiology of various organs of the government. Every government has three organs: executive, legislature, and judiciary. Its composition, its framing, its forming, its functions, all are dealt with under the constitution of a government. And constitution is also called as a Bible of the nation. Every nation has a sacred document called constitution, which they regard as Bible of the nation. So today, to begin with, I will like to share with you in brief, firstly, how the constitution was made, who made this constitution which we are studying. Now remember here, the number of people who worked hard, endeavored to frame our constitution is 300 approximately. To be precise, 299 legal luminaries, high scholars, politicians, constitutional experts worked hard. For how many days, weeks, or months? They worked for about 3 years. So this constitution was framed, to be precise, in 2 years, 11 months, and 17 days. Roughly 3 years were required to frame this constitution. And who were behind framing this constitution? Mainly, out of these 299 members of the Constituent Assembly, Dr. Rajendra Prasad was the president of the Constituent Assembly. And Dr. Babasaheb Ambedkar, he was the chairman of the drafting committee of the Constitution. There were various committees formed to begin with. Provincial Committee, States Committee, Steering Committee, Central Powers Committee, then Drafting Committee, out of which Drafting Committee was most important and most rational. Rational in the sense, all sorts of sentiments were covered, all debates which were gone through in the Constituent Assembly were reflected in the draft of this Constitution of India, which was mainly framed by Dr. B.R. Ambedkar. One name should not be forgotten in this regard. Dr. B.N. Rao. Benegal Narsingh Rao, who assisted in framing of this constitution. We forget him, but we should not forget this name, Dr. B.N. Rao, who was very important personnel in drafting of this constitution, and 3 years were required, I told you in the beginning, for drafting, and it came into force not on 26 January 1950. The constitution came into force on 26th November 1949. This date is mentioned in the preamble of the constitution also. On this date, I repeat, the date is 26th November 1949. The draft constitution was signed by the President of India and all other members of the Constituent Assembly. It came into force immediately on that day, which has been specifically mentioned in the preamble of the Constitution. However, whole of the Constitution did not come into force on this date. Only part of the Constitution came into force on this date. The remaining part of the Constitution and major chunk of the Constitution came into force 2 months later. That is 26 January 1950. That is the date which we celebrate as Republic Day, because major part of the Constitution had come into force on that particular day. So this has to be kept in mind. The preamble to the Constitution runs only in one sentence, but one sentence is a summary of the whole Constitution of India. Preamble contains only one full stop at the end. There are commas and colons and semicolons, and preamble is said to be key of the mind of the makers. Preamble provides the goals, objectives, the aims for making of the Constitution. So we begin with preamble, and what were the contents of the Constitution in 1950 when it came into force? There was a preamble, there were 395 articles, and there were 8 schedules to the Constitution. Constitution is not complete without schedules, but the number of schedules at that time was only 8. Later on, there were many amendments to the Constitution, and presently we have about 450 articles and 12 schedules in existence. And who drafted this Constitution as per the preamble? We, the people of India. The members of the Constituent Assembly did not say we drafted, that means members drafted. Ultimately, members of the Constituent Assembly were our representatives. It was indirect type of election at that time. Provincial Legislative Assembly members were voters for electing members to the Constituent Assembly. So we had elected at that time, that is during 1946, 47, 48, 49, 3-4 years period, for the purpose of completely drafting the Constitution. It was drafted by our representatives, that is those persons who were elected by members of Provincial Legislative Council. So ultimately it is we. Finally, indirectly it is the we, the people of India. And remember here, this phrase, this beginning of the preamble is borrowed from American Constitution. In America also, the beginning of their Constitution starts with we the people of United States of America. On those lines, we have started our preamble and our Constitution. This point has to be remembered. One more point. We have incorporated whatever is good in almost all the constitutions of the world. We had borrowed different principles, different concepts from different countries, their constitutions. To give a few examples, Part 3 of our Constitution, that is fundamental rights, was drafted on the basis of Bill of Rights of America. On that we had copied, but with some amendments. We had our own reservations. we had our own exceptions, we had our own terminology in framing the Bill of Rights. We did not simply copy the Bill of Rights of American Constitution. Secondly, the parliamentary form of government which we have in India was taken from British government. America has presidential type of government. We did not accept that. We chose parliamentary form of government and the principles regarding them, provisions regarding them from the British government. Then emergency provisions were incorporated on the basis of German constitution, German Reich constitution. A special chapter on directive principles of state policy, which very few countries in the world have, very few, which can be counted on the tips of fingers. We adopted from the Constitution of Ireland. So part 4 of the Constitution is based on Constitution of Ireland. Secondly, before this Constitution came into force, was there not any Constitution in India? Yes, there was. A government cannot be run without any Constitution. So it was Government of India Act of 1935, which was passed by the British Parliament, which was in force before our Constitution came into force. And major administrative provisions relating to service, executive, judiciary, legislature, their interrelations are taken from this Government of India Act of 1935. Britishers left, but they left a legacy for India. And whatever was good, we have adopted. So in this way, our Constitution is a kind of mixture of all good things. In almost all the constitutions in India, firstly, I mentioned the name of Dr. B.N. Rao. He traveled abroad. He went to America. He went to England. He went to many other countries to study the working of the Constitution there. And he came back with his feedback, with his report, and he helped the members of the Constituent Assembly, especially drafting committee, in framing the Constitution of India. So whatever was good in the whole world, in many constitutions of the world, were taken, incorporated in our Constitution with modifications, with reservations. It was not simply a copy, but a copy which was suitable for us. Then we shall consider as to the nature of the Constitution, in the sense whether it is unitary or federal. This question is asked many times, whether our Constitution is unitary or federal. Article 1, in its clause 1 of the Constitution, mentions that India, that is Bharat, shall be union of states. Our nation is described as union of states. It is not described as federal state. Nowhere in the Constitution there is a mention that our Indian Constitution is federal. Nowhere. American Constitution is a model of federalism. And Indian Constitution, we are going to discuss in few minutes what type of federalism we have and whether we are federal or not. That is also a question to be asked. Because when the Constitution does not say specifically that it is federal, how to decide whether Indian Constitution is federal, its nature is federal or not? There are 4 main criteria to decide whether any constitution is federal or not. Firstly, there should be dual government. 2 separate governments, central government and state governments, which should be equal in their jurisdiction. They should be coordinate and one should not be subordinate to the other. State government should not be subordinate to the central government. So 2 sets of governments are required in federal country. Secondly, there should be distribution of powers. Mainly there are 3-4 types of powers: executive, legislative, judicial, financial, administrative. These are to be properly distributed between central government and state government. That is the second requirement of any federal government. Third requirement is A federal government should have a constitution which should be written, which should be rigid, and which should be supreme. British government has no written constitution, nor it is presidential type of government, nor it is federal government. So the point here is the constitution, if it is supreme, if it is written, if it is rigid, means difficult to amend, then that is a federal constitution. And lastly, there should be a federal court which can interpret the provisions of the constitution in case of doubt, especially between state government and central government or between state governments. So interpretation of the constitution is a function of a federal government. Whether we have all these criteria, yes, substantially speaking, we do have all these four criteria. We have central government as well as state governments. Both are coordinate in their area. State government is not subordinate to the central government. Similarly, is that distribution of power specifically in the constitution? Yes. There is a distribution. In Schedule 7 of the constitution, there is a list 1, list 2, list 3, which provides for union list, state list, concurrent list. What is that? That is distribution of powers between governments. So we do have distribution of power. Do we have a written constitution? Yes. There is no doubt about that. Whether it is supreme? Yes, there is no doubt about this also. Whether it is rigid? On this point, there can be two opinions. Whether our constitution is rigid or not rigid. However, substantially we can call, broadly we can call it as a rigid constitution. So broadly speaking, our constitution is federal, though it does not mention anywhere specifically. However, there are many provisions in the constitution itself which dilute the principle of federalism. Say for example, governor in India is appointed by President of India. This never happens in federal government. In America, governor of a state is elected by the people of that state. Governor in USA is not appointed, cannot be appointed by USA president. Because both are independent governments, people of the state, they will decide who will be the chief of the state. But here, formal chief of any state is governor, and that governor is appointed and subordinate to the President of India. Another example, central government can give certain directions to the state government in administrative matters. This can never happen in federal government because state governments are autonomous in their own field. They will not take any directions from the central government at all. But in India, the position is different. Our parliament can legislate sometimes in the state list, some matters in the state list, list 2 of the 7th schedule. If Council of States passes a resolution, Parliament can make a law with respect to a matter in the state list. So this is encroachment on states' legislative power, but that is happening in India, especially when we are under President's rule. It is failure of constitutional machinery in the state. Under Article 356, Parliament gets power to rule the whole state. Parliament gets power to make any law on any state subject. This never happens in federal country. There cannot be a president's rule in America, in any state. That is not possible. And Parliament there cannot make a law for the state there. Similarly, in federal countries, judiciary is bifurcated. Federal judiciary different, state judiciary different. In India, we don't have this bifurcation. We have integrated judiciary, a hierarchy of judiciary. And there is no bifurcation of state judiciary and central judiciary. High Court and Supreme Court, they have power to interpret the Constitution and they are part of the hierarchy, Supreme Court being the apex court. There is no separate federal court in India. So that is why in India is integrated. Election Commission is integrated. Election Commission of India not only looks after election of members of parliament, it also takes care of election of state legislature, members of state legislature. Controller and Auditor General of India not only controls the accounts and audit of central government, it also controls accounts and audit of the state government. So this is something which never happens in a federal country. And in a federal country, every citizen is having citizenship of the state and citizenship of the nation. And he has different rights under that. In India, that is not possible. It's only one citizenship. Few more points are there, in the details of which we may not go, but we show that ours is not a federal country. Ours is a diluted federal country. So what is the summary of this discussion? Are we federal? One more point to be referred here is, though there is no mention in the Constitution that we are federal, the decisions of the Supreme Court go to show that we are federal. Similarly, Dr. Babasaheb Ambedkar, what was his view about the nature of the Indian Constitution? He said our country is federal as well as unitary, both. What he said? In normal conditions, our constitution, our country is federal. But whenever there is emergency, it transforms into unitary form of government. So as per the circumstances, as per the requirements, we change our nature. That flexible attitude is available in the Constitution itself. That was the opinion of Dr. Babasaheb Ambedkar. Then we come to another feature of our government, our Constitution. At the state level as well as at the central level, we have parliamentary form of government. Here we should know what is parliamentary form of government and presidential form of government. In America, there is a presidential form of government. What does that mean? So we shall discuss firstly in brief American presidential form of government. There, the President of America, the highest authority, is elected by the people directly. There is no prime minister there. All the powers are concentrated in the President of America. And he does not choose his members, that is ministers, from the legislature there. He chooses from his own choice members of the ministers. And these ministers are not responsible to the legislature. Executive in America is not responsible to the legislature. There cannot be a vote of no confidence against the President of America. He will enjoy 4 years of his tenure. He cannot be removed by this process of no confidence. He has guarantee that he will be there for 4 years. But in parliamentary form of government, which exists in Great Britain, the position is different. Here the executive and legislature are not separate. And the executive is carved out of the legislature. To be a minister, the person should be member of the legislature. Minister is part of the executive, the head of which is prime minister at the central level and chief minister at the state level. So this is the council of ministers. And the members of the council of ministers, there is all ministers must be members of legislative assembly of the state at the state level and members of parliament at the central level. If they are not, within 6 months, they have to get themselves elected, and only then they can continue as ministers. And all these council of ministers, including prime minister, they are responsible to the lower house, that is house of the people. So any day, if a vote of no confidence is passed against them by majority on the floor, they will have to quit. So there is no guarantee that they will remain in power for 5 years. So this ministry headed by chief minister at the state level and prime minister at the central level, they will be in power so long as parliament wants, so long as they enjoy the majority in the lower house. That is parliamentary form of government. So we have adopted parliamentary form of government. Here we have a president, but our president of India is not comparable to American president. Our president has no real powers. He is just a mouthpiece of prime minister. He has no discretion in the matter. He is indirectly elected. So we cannot compare our president with American president. So our type of government is parliamentary form of government, which is like British Parliament and not presidential form of government. Then comes secular nature of our government. This is something special, something liberal, something new. What is secular after all? One point here again has to be remembered. The preamble of the Constitution was amended in 1976, 42nd Amendment. And by that amendment, the word secular was inserted in the preamble. Does that mean that we have become secular after this amendment only? No. We were secular. And there are provisions, Article 25, 26, 27, 28, freedom of conscience and free profession, practice, propagation of the religion. You can enjoy your religion, you can change your religion without any force, without any fear. You can propagate any religion properly, in a proper manner. After all, secular means a nation does not prefer any particular religion. A nation does not confer special rights on majority religion or on any particular religion. There are no special rights, special status, special position, and there will not be discrimination on the ground of religion at all. State will treat all religions equally, and public funds cannot be utilized for propagation of a particular religion. It has been held in many cases, including Keshavan Bharati, that secularism is a basic feature of the Constitution and it cannot be amended. Now you will say, what is special about secularism? We are providing equality to all persons belonging to any religion. There is something special. And that is, if we see our neighboring country, I will name Pakistan, in its 1972 constitution, it is specifically mentioned that Islam will be preferred there. So their constitution is not secular. Our neighbor's constitution is not secular. They never mention the word secular. They specifically say Islam will be preferred. They specifically say all religions in Pakistan, persons belonging to all religions are not equal. They don't enjoy equal rights. Person belonging to Islam religion will be preferred in many matters. So when our neighboring country is not secular, we have shown courage to be secular. So this is very important. We could have given special preference to a particular religion in the drafting of the constitution, as Pakistan did. We could have done that. We did not do. Because we are tolerant, we are liberal, we don't go by fundamentalism, we don't go by religionism, and that is why we provided for secularism, that is, there will be no discrimination on the ground of religion at all. That is the concept of religion, secularism to be considered. A democratic government, preamble itself mentions this word, sovereign socialist democratic republic. Democracy means rule of the public. Who are rulers here? Demo means public. Cracy means rule. When public rules, it is democracy. When one person rules, it is monarchy. When few persons rule, it is aristocracy. When one person behaves like a dictator and rules, that is dictatorship. Democracy, as the name suggests, shows that persons who are ruling are common man. How can we explain this concept that common man is ruling and can rule, and only he can rule the government? We are voters. Everybody who has completed age of 18 years can vote at the time of election, which comes every 5 years, and decide the fate of present government. Decide whether to allow present government to continue, or we can decide some other government coming into power in its place. Who decides? The common man decides. Common man decides by majority. Who will remain in power? Which party will come in power? Which party will lose power? All this is in the hands of citizens of India, a common man. That is why this is called a democracy. This is irrespective of religion or age or payment of taxation or property or gender. I will explain this sentence specially. It is universal franchise. Everybody in India who is a citizen of India, and only one qualification, that he or she should have completed the age of 18 years, because he or she should be mature enough to know what is good for the nation, what is good for the country. Do you know, roughly 100 years back, there were elections in India and abroad also of political functionalities. But do you know that women were not allowed to vote? Women were not voters 100 years back. So this is a change. Women are not only equal, they are voters. Half of the population of India was devoid of voting right 100 years back. Now, irrespective of the sex, that is gender, male or female, both have voting right. During British period, whenever there were elections, a voter could be that person who had certain immovable property, who had a house, who had agricultural land, or who paid taxes to the government, only could vote. Because he is paying for government, he has a right to vote. But now we have removed all these restrictions. This change has to be noted. A person may be a beggar. Yes, beggar. He may not have home. He is lying on the street. He has no property, not single rupee. He has a voting right. If he has completed 18 years of age, he will vote and he will decide the fate of his own country. Person may not pay tax, person may not be having property. He still will have right to vote. So there is a democracy, a rule of the public, and republic. The word republic is added, democratic republic. Republic meaning hereby the formal head of the nation is elected, though he does not have real powers. President of India, for example, is elected indirectly in India as per the provisions of the Constitution, but he has no real powers. He has to accept all advice and recommendations made to him by Prime Minister of India, who is the head of Council of Ministers. This is similar to Crown in Great Britain. In Great Britain, there is a king or the queen even today. Formally, the head of Great Britain is king or the queen, but they are simply formal. So we don't have queen or king, which is a hereditary proposition. We are republic, that is why we elect every 5 years President of India. So democratic republic is another concept prevalent in the Constitution of India. Now, I will discuss few points on amendment of the Constitution. Can Constitution be amended? Certainly. Article 368 of the Constitution makes provision for the procedure for amendment of the constitution. Amendment may be needed because there may be changes over years, over decades. Certain new provisions need be required to be incorporated in the philosophy of the constitution. Then amendment will be needed. What is the procedure? And here we will discuss whether our constitution is rigid or not. That point also was left undetermined earlier. There are three ways in which constitution can be amended. There are certain provisions of the constitution for amending which a simple majority in the parliament is required. My emphasis on simple majority in the parliament, more than 50% votes. Which are these provisions? For example, if any state is to be divided into two states, or two states are going to be merged, or area of any state is going to be changed, say for example, state of Telangana was created from state of Andhra, constitution has to be amended because schedule 1 will change whenever there is a change in a number of states, area of state. Whether Article 368 comes into picture in such cases? No. That will not be treated as amendment of the constitution if it is changing the areas or boundaries or names or fusing two states into one or dividing one state into two. That change of constitution, which will be required in this case also, will be by simple majority. Some states have legislative council at the state level. State of Maharashtra also has legislative council here. All states do not have. Only 4 states in India have legislative council. If this is to be abolished, or in those states where there is no legislative council, it is to be newly created. In this case also, constitution requires to be amended, but a simple procedure of simple majority is sufficient. Schedule 5, Schedule 6 relating to administration of scheduled tribes is to be amended. Here again, a simple majority in the parliament is needed. This is one type of amendment, one type of procedure for amendment. Second type of procedure is by special majority. What is special majority? It's not just merely 50%, more than 50%. It is 2/3 majority of members present and voting. 2/3, meaning there were 66.6% votes. I repeat, 66.6% votes in favor of any resolution will be special majority, which should also be majority of the total membership of parliament. All total members of the parliament may not be present, but whatever their majority of the total number, and also 2/3 majority of members present and voting, a double type of majority is required in special majority. So major chunk of the constitution can be amended only in this way, by special majority. There is a third type of procedure for amendment of the constitution. This is necessary if any judicial powers are to be changed, powers of the president are going to be changed, a list of council of states membership is to be changed. This special procedure is required, which requires not only 2/3 majority, not only special majority, plus it requires ratification by the states. Minimum 50% of the states in their state legislature should agree for this amendment by passing a resolution, then only this amendment can come into effect. In America, for amending their constitution, the number of states which are required to consent is 75%. Here it is 2/3, half. In India it is half. For special majority it is 2/3 plus half the states here. So our constitution is not as rigid as the American constitution. That is why our constitution could be amended more than 100 times. Remember, We have amended our constitution more than 100 times. So amendment is possible. However, amendment of fundamental rights was a controversial question during 1950s, 60s and 70s, but which is settled now. Can fundamental rights be amended so that they may be reduced or abridged? Because we have whether constitutional amendment is law for this purpose. In the first case, Shankari Prasad, Supreme Court had come with the view that yes, any part of the constitution is amendable, including fundamental rights. Any part is amendable by following the procedure in Article 368. But in Golaknath versus State of Punjab, the same Supreme Court in 1967, by 6-5 majority, it was a bare majority, margin majority, 6-5 majority, held that fundamental rights cannot be amended because they are fundamental. So there was a restriction put on the parliament on amending powers that you amend any part of the constitution, not fundamental rights. However, this ruling of the Golaknath was overruled in Keshavan Bharti versus State of Kerala in 1973. And here the court ruled that fundamental rights also can be amended. But a rider was put on that. Any part of the constitution can be amended, including fundamental rights, subject to condition that basic features of the constitution cannot be amended. Now, what are these basic features which are unamendable? Various examples were given by Supreme Court judges, but there was no unanimity. So the present position as to amendability is any part of the constitution can be amended, fundamental rights also can be amended, but no amendment should violate the basic structure or fundamental features of the constitution. Then we shall come to position of judiciary in India. Independent judiciary with the provision for judicial review. Independent, this is very important. A judiciary should not be under subjugation of the executive, otherwise the judgments would be flawed. Judgments would be biased, and judiciary should be protected by the constitutional provision itself. An important provision as to judicial protection and maintenance of independence of the judiciary is the procedure for removal of High Court judges and Supreme Court judges is very, very, very difficult. Special majority in Parliament is required, but few more provisions are there which are very difficult to remove High Court or Supreme Court judges. Till today, from 1950 to 2022, not a single High Court judge could be removed, not a single Supreme Court judge be removed from his or her position. But there was a move, there was initiative, there was procedure started for moving High Court judges as well as one Supreme Court judge, Ramaswamy, Justice Ramaswamy. But actually, in fact, few of these judges resigned themselves and there was no removal in such cases. Their appointment. Who appoints them? Highest authority in India, President appoints. But we have seen that President is governed or directed by the advice of Council of Ministers, headed by Prime Minister. But in this case, that is not the matter. Constitution specifically mentions that President of India has to consult the judiciary itself. President of India has to consult Chief Justice of India, few of the judges of the Supreme Court, few of the judges of the High Court for appointment of higher judiciary, that is High Court judges or Supreme Court judges. So here the view of the judiciary itself, will have to be taken into consideration while appointment. Salaries of judicial officers, High Court judges, Supreme Court judges cannot be reduced to their disadvantage during their position. They have power to punish for contempt of court. There is a special power. So in this way, our judiciary is independent and from various decisions which it has given so far, we can form an opinion that the judgments given by our judiciary, apex judiciary as well as High Court judiciary are notable, noteworthy, remarkable, profound, based on the philosophy of the Constitution. Our judiciary has power of judicial review as well. This phrase judicial review has a special connotation, special meaning. If state executive or central executive or parliament or state legislature violates any provisions of the Constitution, so executive or legislative act of the government, if it violates any provision of the fundamental rights, then Supreme Court or High Court can strike down that executive action or legislative action also. Few examples of striking down laws on the basis that they violate fundamental rights. One example, recent example is this section 497 of Indian Penal Code, adultery. Section 497 of Indian Penal Code was struck down by the Supreme Court on the ground that it violates Article 14, Article 15, Article 21 of the Constitution of India. Similarly, Section 377 of Indian Penal Code, dealing with unnatural sex, which was not exactly struck down, but which was trumpeted, abridged, read down, that homosexuality is not basically illegal or unconstitutional, that is protected under Article 15 of the Constitution, 21 of the Constitution, and there cannot be arbitrary decision on the basis of Section 377 of Indian Penal Code. That is why homosexuality between consenting adults in private does not violate Article 377. So Section 377 was read down. Section 303 of Indian Penal Code also was struck down on the basis that it violates Article 14, Article 21 in the case Me Too versus State of Punjab. So that is judicial review. A law can be struck down, executive action can be struck down if judiciary finds that it violates any of the provisions of the fundamental right. Lastly, we will take emergency provisions. There may be crisis, national crisis. There may be impending war. There may be external aggression, not exactly war. In such cases, Constitution of India makes provision for imposing emergency under Article 352, which has to be proclaimed by the President of India. And when this is proclaimed throughout India or even part of the India, what will be its effects? Firstly, Article 19 fundamental right gets suspended. Nobody will have various freedoms. Under Article 19, Clause 1, Subclause A, B, C, D, E, G. Other fundamental rights also can be suspended, meaning thereby enforcement of other fundamental rights can be suspended during emergency, except Article 20 and 21, which cannot be suspended. So people will not have fundamental rights because it is a critical position for the government of India to protect itself. Some controls are necessary on the citizens of India. And in this emergency, under Article 352, central government will totally control the state government. Any direction can be given by the central government to the state government, which will have to be obeyed by the state government. Laws can be made with respect to any matter in the state list by the Parliament of India, which normally cannot be made in emergency, this can be made. Financial arrangements of distribution of financial powers can be changed during this emergency. So these are some consequences of national emergency. Secondly, we have what is called as President's rule. Constitution does not use this phrase President's rule. Under Article 356, failure of the constitutional machinery in the state. This is a long phrase used for this type of emergency. When it is proclaimed, when the government of any state cannot be carried on in accordance with the provisions of the Constitution. Its effect will be ministry will be dismissed. So there will not be any state government. There will not be chief minister working. Legislature will be suspended or dissolved. And all work of the state will be run by central government. Executive work, legislative work. Who will run the government? Governor of the state. He will run according to the directions of President of India. Till today, more than 100 times, this type of President's rule has been imposed in India, and there is a political misuse of this article being made many times by all political parties, not in particular political party. But national emergency, which I explained few minutes back, was imposed only 3 times in India. When there was Chinese aggression in 1962, in 1971, Pakistani aggression, 1977, on the ground of internal disturbance. Lastly, there is financial emergency under Article 360. Till today, we have not faced this financial emergency, but provision has been made in the Constitution for financial emergency as well. Whenever stability or credit of the government of India is threatened, this type of emergency can be imposed. Few last remarks about fundamental rights, directive principles, and fundamental duties. Part 3 of the Constitution deals with fundamental rights which are enforceable. If there is violation, the person whose right is infringed, he can approach the court, and he can approach the High Court and Supreme Court. Alternatively, directly, he need not go through proper channel. There is lowest court, then upper court, then higher court, then highest court. For a violation of any of the fundamental rights, the person can approach directly the High Court or Supreme Court, and various writs will come to his help. Writ of habeas corpus, mandamus, prohibition, quo warranto, certiorari, and power of the Supreme Court and power of the High Court is similar in this regard. So that is about fundamental rights which are enforceable. We have directive principles which are not enforceable. Part 4 of the Constitution provides for directive principles. These are directions to the government. These are moral instructions to the government, how the government is to be run. These are not enforceable. But if any law is made to implement directive principles, then that law is enforceable. We have not taken steps to implement all the directive principles. One example is Uniform Civil Code, not implemented till today, because so it is not enforceable as such. You cannot go in Supreme Court and ask for the mandamus of the Supreme Court to the legislature, to the parliament, that make law on this point because it is provided in directive principles of state policy. No, cannot be done. This is a moral instruction which will be followed by the government because government wants future political life at the time of next election. If it has not taken steps to implement directive principles, people will think whether this government should be re-elected in the next election. And what is fundamental duties? in original constitution, there were no fundamental duties. But during Indira Gandhi regime in 1976, by 42nd Amendment, a new part 4A, containing only one article, Article 51A, which contains 11 clauses, provides for fundamental duties to respect national flag, to protect environment, or to develop scientific temper. Now, this chapter on fundamental rights is similar to directive principles. It is not enforceable as such unless a law has been made to implement the directives. They are not enforceable. Say, for example, to develop a scientific temper, to develop excellence in all fields. This is a direction to individuals. But if they do not do that, what punishment to them? Nothing. This is a guideline to a common man, to the citizens of India. Just like directive principle is a guideline to the government, fundamental duties, these are guidelines to the citizens. They should follow this in their interest, in the nation's interest. With this, I conclude. Thank you very much. Thank you.
Thank you, sir. Thank you, sir.
Thank you, sir.
If any
Thank
student
you.
wants to ask difficulty, he may ask. If any student wants to ask any query or difficulty, I will answer.
Hello. Right now, we don't have received any query
Okay.
from.
Okay, it's all right.
Thank you so much, sir, for your valuable guidance. Now, I would like to request Siddharth Wagmare to give vote of thanks. Over to you, Siddharth.
Hello, hello. May I audible, sir?
Yes,
Yes,
you are audible.
Sorry, sir. Network issue येतोय, but it's okay. Thank you, Soha. Myself, Siddharth Arun Wagmare from NLC 4th. I would like to thank our college, Ismail Saib Mullah Law College, Satara, and Honorable Dr. Sujata Pawar Ma'am, Principal IMLC Satara, and Career Katta for the organizing JMFC and CGAD lectures series. The knowledgeable and the experienced resource person, the Honorable Dr. H.G. Kulkarni sir, for enlightening about the silent features of the Constitution of India. Today we got to know the gist of the Constitution, whole gist of the Constitution. Just because you have explained it so well to all of us, we are grateful for your valuable guidance and valuable times. So thank you so much, sir. I would like to thank to coordinator of the Career Katta group, Assistant Professor Sri Nikumb sir, to giving a chance to my opportunity to present this session, as well as the librarian. Hello,
Yes, you are audible. I think he's offline. So I would like to complete vote of thanks which were given by the Siddharth Wagmare. I would like to express my vote of thanks on behalf of Ismail Saib Mullah Law College, Satara. Already he have completed other part of the vote of thanks. I just express my vote of thanks on behalf of Law College, Satara. We have technical assistant from the Mukri sir. I would like to express my vote of thanks for the said support. I also express my vote of thanks on behalf of Ismail Saib Mullah Law College, Satara, to students and various other legal fraternity, those who have attend this program. I express my vote of thanks. Thank you for joining with us. With kind permission of our principal ma'am, I would like to declare that today's program is over. Thank you, madam. Thank you, sir.
Thank you, sir.
Yes.